A very warm good morning to all of you. Today is the second important engagement on the issue of separation of powers. Idea of separation of powers, different dimensions regarding the genesis and origins of separation of powers. Fundamentally understanding the notion of separation of powers within the architecture of constitutional provisions, or in other words, we can collectively put this entire notion of idea of constitutional mechanism with regard to separation of powers is of vital importance. And we should not forget this particular point, my dear friends, that the idea of separation of powers basically comes from the Constitution per se. It is the Constitution that allocates powers among the various branches of the state. So therefore, there is a collateral point, and that collateral point establishes the importance, primacy, supremacy, and centrality of the constitution of any geopolitical entity, particularly the well-established democracies, emerging democracies, fledgling democracies, and evolving democracies. Because it is the constitution, my dear friends, that restricts the manner in which each branch can act. There are certain important restrictions, limitations, riders, and conditions which have been contemplated by the constitutions or within the schematization of the constitutional document. And these limitations appear designed to preserve a balance among the branches and to promote governmental accountability in a given situation. Although it would be prodigal on my part to claim that we can learn the framers' original understanding of the separation of powers or doctrine, the available historical materials are certainly compatible with and indeed reinforce this particular premise that the importance of delineating the distinct modes or models of action contemplated in the constitution for the three branches of the government or the state. If you take into account the entire idea within the constitutional framework, then the reification of separation of powers theory in the constitution, my dear friends, departed substantially and normatively from previous theoretical models which have been contemplated by various scholars, including Montesquieu, Aristotle, John Locke, and the subsequent one like Madison and Harrington. The focus in the constitution is not so much on keeping the branches separate. If we are going to discuss or we are going to understand the idea of this entire what we call mechanism, which is known as the separation of powers, the focus that has been identified in the constitution is basically on constructing a scheme of checks and balances, which is today known as, in the popular parlance, the emergence and establishment of the idea of constitutionalism. Although the powers of the government are kept distinct and separate for the most of the part of any kind of a constitution, and each branch is also to be accorded the necessary constitutional means and personal motives to oppose the encroachments of the others. And that should be taken the pervading line of argument in the constitutional scheme, even if that permits one branch to participate in the functions of another. The framers, my dear friends, made the branches interdependent, and this should not be forgotten. Because the regimentalization of separation of powers is not at all possible within the constitutional scheme, or in other words, let me put it like this, that even in ancient times, or even in modern times, my dear friends, it is not at all possible to contemplate a regimental or military kind of what we call, regnant and independent existence of each and every branch within the constitutional scheme. That is not a possibility. Minor overlappings, positive encroachments, and interdependence idea is reflected in the allocation of powers among the various branches within the constitutional framework. And this has been the case with each and every constitution, where we find that certain important what we call understandings regarding separation of powers are reflected in the constitutional scheme. However, constitutional scheme also reflects interests, my dear friends, in making the branches responsible to some higher, I should say, the public interest, higher public interest. The framers included checks and balances not only to prevent each branch from accumulating, concentrating power at the expense of other branches, but also to protect against the rule of faction, primarily in the legislative branch. This reminds me of one of the most important asseveration that that was offered by medicine, perhaps the leading what we call spokesperson for the constitution, who defined factions as a number of what we call of citizens, whether amounting to a majority or minority of the whole, or who are united and actuated some kind of a what we call, or by some common impulse of passion. At the same time, opposite to what we call, or adverse to the rights of other citizens, or to the permanent and aggregate interest of the particular community. Even if the branches were kept separate, my dear friends, representatives of the people could become captured by the spirit of faction or narrow-mindedness and exercise governmental authority at the expense of the public liberty. Instead of striving only to maintain a balanced government, as had prior separation of powers theorist, medicine defended the scheme as a means of what we call protecting individual liberty from arbitrary governance, even by the democratically elected what we call legislature or parliament. Therefore, we can say that the constitutional structure places a premium on accountability among the branches and on responsibility to public interest. Separation of powers, my dear friends, or the separation of powers concerns and issues as they arise what we call in the contemporary circumstances or today, must therefore be addressed by examining not merely the separation model envisioned, contemplated by classical what we call theorists, but also the checks and balances that distinguishingly mark the governmental structure in the constitution. And more particularly, my dear friends, the internal checks in the constitution, some subscribing the manner in which each branch can act also be understood as part of the what we call, holistic effort to confine governmental authority and instill governmental responsibility. Here, let me point out, when we are, talking of responsibility, my dear friends, responsibility in this particular, context is somewhat misleading, I should say, because it does not reflect a purely democratic responsibility to the electorate, but refers to responsibility to a higher public good, which I have earlier pointed out. Higher public good. It is the most important, what we call, most important element of the separation of powers principle. Higher public good under all circumstances be recorded in a manner that does not violate and that does not what we call at variance with the constitutional scheme. Then only we can appreciate the governmental responsibility. Because in the light of the difficulty of ensuring a balance among the branches, the framers supplemented the general separation provided in the constitution with more specific restrictions, conditions, riders governing the ways which branch can act in a particular manner. To medicine, suppose medicine was of the view at the time of the framing of the Constitution of the United States of America. He was of the view that an effective system of separated powers could not be maintained merely by separating the branches, nor even by inserting external checks such as the power of impeachment or the power of judicial review. He was of the view, my dear friends, that a mere demarcation on parchment of the constitutional limits of the several departments is not a sufficient safety wall or some kind of a guard against those encroachments which lead to a tyrannical concentration of all the powers of the government in the same hands, or in one hand, or in a coterie. Therefore, the boundaries of the three departments of the three branches, as per the Montesquieuan orientation of the separation of powers, which have been adumbrated in the constitution or invariably in all the constitutions, could not protect against the encroaching spirit of power, because it has been very swiftly acknowledged that there was no functional way of separating the branches. And my dear friends, remember one thing: experience has instructed the human mind. Experience, tells and guides human mind that no skill in the science of government has yet been able to discriminate and define with sufficient what we call, maturity, certainty, and determination. It's three great, provinces, which is popularly known as the legislature, executive, and judiciary, and all these, three branches. But this reminds me at this stage of another important, view that has been expressed by, Hamilton. Hamilton was of the view, and he was also having some kind of a similar view, and he observed that the insufficiency of a mere parchment delineation of the boundaries of each branch of the government has also been remarked upon. Therefore, we can say that the goal of the constitutional scheme was to contrive the interior structure or internal what we call structure of the government, as that is, or its several constituent parts may by their mutual what we call relations be the means of keeping each other in their proper places. Because it's very, very important for the smooth functioning of the governmental machinery that whatever the allocation in the name of the separation of powers have been or has been, contemplated in the schematization of the constitution of a particular geopolitical entity that must be reflected in the functioning of those very institutions. Because the medicine has also explained this particular, what we call, a famous Federalist paper. Federalist papers number, what we call, 51. And this is my humble submission to all of you whenever you find time, my dear friends, not from your examination point of view. So far your end-term examination is concerned, I'm not at all going to prescribe anything for that examination. But as an independent researcher, if you are having some, or evincing some kind of interest in the comparative constitutional law of SAARC nations or comparative constitutional law per se, you must study Federalist paper number 47, 48, 49, 50, and 51. That is my recommendation. Because when we confront with this issue of separation of power, my dear friends, then it may be a reflection on human nature. A reflection on human nature that such devices should be necessary to control the abuses of government. Because any kind of a concentration of power bound to corrupt, bound to make what we call, or give some kind of, unfettered powers. And it may be akin to the emergence of, tyranny or tyrannical tendencies in a particular, what we call, constitutional position. Therefore, the basic fundamental principle behind the separation of power, principle is that there should not be any kind of a, arbitrary exercise of the constitutional authority or constitutional powers. There should not be any kind of an abuse of, power. But what is government itself but the greatest of all the reflections on human nature? That is another important, what we call, question. My dear friends, if man were, angels, a famous, what we call, quote, no government would be necessary. If angels were to govern man, neither external nor internal controls of the God, particularly on the government, would be necessary. A famous, what we call, dictum that has been, what we call, that was, there when Constitution was being, framed at the Philadelphia, Convention. In framing a government which is to be administered by man over man, the great difficulty, my dear friends, lies in this particular, premise. We must first enable the government to control the governed, and in that very, next place, oblige it to control itself. A dependence on the people is no doubt the primary control of the government, but experience has taught humankind the necessity of the, collateral precautions, auxiliary, what we call, notions or dot of, cautions. And it becomes very, very important when we are, seized with this, collateral precautions, and we becomes very, very, precautious, or internal controls, you may call them, in other words, are a unique contribution to our, system of, constitution making, particularly in the arena of separation of powers. My dear friends, a scheme of separated powers is to a certain extent, I should say, self-executing by circumscribing the ways each branch can act. The Constitution attempts to minimize clashes among the branches. That is the most important, what we call, premise behind, as a fundamental, principle behind the, acceptance of the idea of, separation of powers. So we should not forget. And that is why, my dear friends, since charity begins at home, to understand in the right kind of a perspective the idea of, separation of powers, that begins from our class itself. Each and every subject in LLM first semester, my dear friends, has been, allocated to a particular, individual. Each individual has been what he called subscribing to the normative and substantive understanding, how to teach, how to regulate, how to conduct, how to interact. Because the individual reflection is also appreciated. My colleagues are also, dealing with all of you, and they are also dealing with their respective subjects. But we are not encroaching. We are not overlapping. We are not what you call, violating our briefs. Those certain important what we call references are, made. Certain important, deliberations take place which are having some inclinations or some what we call, oozing branches of, deliberations which are coming in another important, area. But because of the interdisciplinary character of our, submissions, we try to accommodate, but we do not encroach. So that is known as, my dear friends, the auxiliary precautions. That is known as the collateral what we call respect. And there should not be any kind of a, encroachment. But what is important is that the, deliberations, delineations, paradigms, principles must be put in the right kind of a, perspective. And that is the, understanding when we are, taking into considerations. And that is the, reason, my dear friends, that Constitutions places checks on all three branches. It basically subscribes the legislature, most rigidly. So this should be taken into consideration whenever any kind of a, deliberation is, taking place on the idea of what we call of, separation of powers. My dear friends, the Constitution of the United States is almost what we call, completing, and very soon it is going to complete 250 years of its existence. And I submit that the Constitution of the United States of America, no slander to recognize, that the, 1787 document was born of the prudent compromise. Sometimes constitutions have been the result of what we call of, compromise. And these compromises are generally, my dear friends, are taken for the welfare of the people. Let me give you certain important examples as well on this particular, understanding. If you take the example, apart from or in addition to the US Constitution, the entire understanding of human rights, which is reflected in the adoption of the Magna Carta in 1215, and subsequent declarations, including the most notable and remarkable declaration ever agreed upon by the collective wisdom of the international community of nations, and that is reflected in the Universal Declaration of Human Rights in 1948. I perceive initially that the most mature minds, on the basis of their vast experiences of war and peace, Universal Declaration of Human Rights came into existence. And I perceive it, my dear friends, not only the preamble to the universality of human rights, and all the preambles to the various, constitutions of many what we call, demographies, geopolitical entities. But at the same time, Universal Declaration of Human Rights must also be understood in political terminologies. It should be taken as a political compromise among the nation states immediately after the conclusion of the Second World War. So therefore, constitutions to some extent may also be construed as political compromises, particularly in those, territories which are full of multiculturalism, diversity, and multilateralism. If you take into account, my dear friends, another important, constitution from our, neighborhood, I am talking of the, constitution, particularly the constitution of Afghanistan of 2004. It was basically a political compromise that arrived in Bonn in Germany in 2003. That was subsequently, adopted by the Hamid Karzai government at that point of time in Afghanistan as the Constitution of Islamic Republic of Afghanistan. Similarly, we can attribute this line of argument, what I have, submitted for your consideration, to the, to this particular, document of 1787, which is today known as the Constitution of the United States of America. Because the Constitution of United States of America has been derived more from experience than from doctrine, and that it was received with an ambivalence in no small part attributable to its what we call, ambiguities. In reality, its most stalwart supporters doubted its capacity for a long life. Various doubts were, expressed at the Philadelphia Convention about the longevity, maturity, certainty of the Philadelphia Convention. And it should not be surprising, my dear friends, that even today there is a disagreement of whether the Constitution of 1787 is now merely an artifact of late 18th century American history, which has in fact, controlled the allocation of the government powers and restraints on those, powers throughout the 2 centuries or more than 2 centuries since its what we call, adoption. In fact, my dear friends, this reminds me of a very, very important constitutional expert, Professor Paul Finond. He invoked the language that regarding the Constitution of the United States of America, and has been, and he was of the view that the Constitution, since its beginning, both as a structure and as a organism, which does not permit it to be treated merely as an upper caste statutes or a learned what we call hand might have had it in the right kind of a perspective as a mere what we call council for moderation, for having some kind of elements of modernity. If you take into account the other parts of the Constitution of the United States of America, you will come to know that the Constitution of the US will necessarily have meanings dependent on the context in which they are being applied. Therefore, my dear friends, added to these are fundamental conceptions that are not attachable to any particular words or provisions. For example, federalism, separation of powers, judicial review, that must be worked out by addition and subtraction of the language and the history. To oversimplify, my dear friends, when we are grappling with the idea of constitutional meaning of the separation of power, as we tend to do, especially when we talk of the constitution on celebratory occasions, We also celebrate the Constitution Day in South Asia as well. It is basically an exercise to ignore what, in fact, the founders basically contemplated regarding Constitution and its efficacy in a given situation. Whether it is the Constitution of Nepal, whether it is the oldest constitution in South Asia, I mean the Indian Constitution or the Constitution of India. We basically take into account some kind of exercise to sophisticate constitutional meanings, as we tend to do when we write juristic articles or writings or briefs or judicial opinions. For the specialist who read them, tends to what you call substitute the subjective for the objective and to cover over the concerted or conceit with some kind of a what you call rhetorical asseverations. The document was to protect of what you call, or let me put it like this, my dear friends. In my personal understanding, constitutions have been designed, constitutions are generally created, constitutions are generally contemplated, constitutions are generally envisioned only for one single purpose. I don't know whether you are going to agree with me, but I am ready to accept your disagreements. I only see, my dear friends, the constitutions are generally designed and drafted to protect only one item which is relating to the human existence and without which we cannot survive. And it is popularly known as the age of reason. I personally feel that it is the age of reason ever since the humanity on this beautiful planet has attained the age of discretion, the age of what we call of vision, the age of understanding, the age of fairness, the age of reason. We require constitution. Constitutions have been designed just to protect the age of reason. Its understanding should come through the use of mind. What is good, what is bad, because it cannot be, my dear friends, factored to provide easy answers even by most modern of what we call of computers or the idea of artificial intelligence. When we are talking of artificial intelligence, we are basically talking of reason. Mathematical permutations, combinations, equations, algorithmic understandings are nothing but that has given us an age of reason. So this age of reason must be protected. And for the protection of the age of reason, my dear friends, we require constitution, and constitution must have some kind of scientific allocation of powers to different kind of institutions which have been created under the constitutions for the common good. Because if you take into account the original constitutional notions of division of powers and functions, which were primarily based not merely on the separation of powers, but on a concept of balanced government. And balanced government was one premise. Another premise, my dear, was the checks and balances, principle. If the three ideas, three concepts, my dear friends, based on a single base of what we call of mistrust, a mistrust of the governmental authority concentrated in the same hands, definitely they were far from the same in their forms. And therefore, checks and balances suggested that it should be taken as a joinder, not as a separation. Separation of two or more governmental agencies, my dear friends, before any kind of action could be validated, or oversight of one another by another. Supervision or the supervisory role that has been what you call contemplated in some kind of a what you call or in some sectors or situations. When we are, talking of the balanced or the mixed, what we call, government involved separation, but by way of providing different, what we call, voices for the different elements in a society, as with the, crown, president, lords, Lok Sabha, Sansad, and the, commons in England, the anticipated elite quality of the Senate or its, putative role as representatives of the, what we call, of, states. In those, what we call, situations, my dear friends, it should be taken into consideration, because separation of powers certainly encompasses the notion that there are fundamental differences in governmental functions, frequently but not universally denoted as legislative, executive, and what we call, judicial, which must be maintained as separate and distinct, each sovereign in its own, area, none to operate in the rim assigned to another. The tendency even today is to think of the, constitutional separation of powers in these, terms. What Medicines wrote in 1788, my dear friends, remains very, very true even today, and has proved true in the, what we call, in the final, or what we call, penalty weight understanding. And he rightly, pointed out, my dear friends, when he was, writing and contributing in papers which is known as the Federalist, what we call, papers, and he was of the view, my dear friends, that the experience has instructed the human mind that no skill in the science of the, government has yet been able to discriminate or, define, which I have already submitted for your consideration with the sufficient, what we call, certainty. So therefore, it is the, questions on the basis of, daily transactions in the course of what we call, of, practice, which prove the obscurity which reigns in these, what we call, issues and subjects, which puzzle the greatest, what we call, depths in the political, what we call, science. So therefore, the consequence or inferential, consequence has been that the problems of the separation of powers have more often been sought to be resolved by invoking one or the other of the, classifications as a shibboleth that, Holmes and other, what we call, jurists like, Cardozo referred to as judgment by labels. Therefore, the life of the, Constitution, my dear friends, from its birth to its, what we call, conclusion, and whatever the, journey a particular, Constitution has contemplated or completed or likely to complete, has not been theory but experience. So therefore, the experience is the basic and the most fundamental guide that ultimately came out with this particular, notion of, separation of power. So therefore, we have been, what we call, witnessing the rise and fall of the, separation of, powers, and that rise and fall of the separation of powers must also be, understood in the given, what we call, situations, because when we are, talking of experience, then experience must be only guide. Reason may mislead us because it has been also, what we call, ordered, but I can say that these kinds of, jurists like, Holmes and Dickinson, another important, what we call, personality, was basically discounting the deductive logic in favor of assaying effects, adverse effects, positive effects that were known, rather than those merely inferred as a priori, what we call, method. The notion has been, my dear friends, and this notion has been reiterated by prominent, what we call, contemporary historians, particularly the professor, what we call, Stephen Morgan, a constitutional, what we call, authority, who came out with the idea of the social compact, fundamental law, separation of powers, human equality, religious freedom, and the, superiority of the republican governmental character. And these ideals must also be reflected in each and every, constitution. So that is the, beauty of the, separation of powers. But if Englishmen supplied the intellectual, foundation, both for the overthrow of the English rule and the, construction of the Republican, government. Then the, United States of America put the ideas into practice and drew on American, what we call, experience and traditions to devise refinements and applications of the greatest, what we call, importance. And the United States, constitution has always been, this is the reason that in majority of the, what we call, global South nation states, so far their freedom struggles were, concerned, they have derived and heavily relied upon, so far their constitution making was, concerned, they transmigrated. They got this kind of a transmigration from the, so far the constitutional ideas were, concerned. They heavily relied upon the Constitution of the United States of America and their, constitutional experiences. So we can say that the separation of the governmental powers into a threefold, what we call, mechanism, which was an older and more familiar way of checking depravity, was, rendered far more effective by the existence of a written constitution, resting directly on popular approval, I should say, or the sovereign, approval. And who is a sovereign? We, the people of a particular, geopolitical entity. The written constitution also proved its effectiveness in the subsequent, what we call, years, by perpetuating in United States of America and other important, what we call, emerging democracies, the operation or the majesty of the judicial review, of executive veto, and of a, powerful upper house of, legislature, as we have been, witnessing in our part of the, democracies. I am talking of the South Asian democracies, which had been or would be lost, what we call, in some of the, emerging, democracies, including some of the South Asian democracies, where the constitutions was, written and consisted of, customary procedures that could be altered at the will of, what we call, of the some kind of, political personalities. But so far the American concept of separation of powers is concerned, my dear friends, this is the, what we call, I should say, the prime example of the proposition that the experience rather than theory grounds the, constitution. In no small parts, this consequence is attributable to necessity rather than choice. Therefore, I am of the view the necessity of the separation of powers derives from the fact, as it has been, what we call, pointed out, particularly by two important, what we call, jurists of the, past, Montesquieu and John Adams, and they have rightly, what we call, pointed out that as it has been, adopted by the American, constitution, that the idea of what we call of American government was primarily sui generis. It was not possible to trace all its, provisions to any of the almost unlimited antecedents invoked at the time of what we call of the Philadelphia Convention. And if we take into account Aristotelian orientation of the separation of power, Montesquieuan orientation of the separation of powers, then it is further, what we call, reflected. But what is important is that its evolutionary, what we call, inklings have not been sufficiently and appropriately, what we call, addressed. Any questions as of now? Now I take you to another important, what we call, dimension of our understanding, and that dimension is relating to the idea of the separation of powers in, South Asia. Any questions? Yes, Mr. Bhagwan. Mr. Bhagwan Das Meghwar, do you want to say something? Yes, Mr. Amit Kumar. Anything?
Can you hear me, sir?
Yeah, Mr. Bhagwan.
Sir, as I'm saying that the separation of power right now in Pakistan, the separation of power is also ruling here.
Hmm.
being a separation of powers, there are destruction of the fundamental rights, right of education. In Pakistan, there is a local government system.
Hmm.
So, being every province have their own local government system.
Hmm.
Due to this, sir, now the Punjab is in majority, so there is a education system is different as
Hmm.
compared to say Balochistan and KPK. And
Hmm.
right the elections time and also local government bodies elections were also conducted in different provinces. So, sir, what do you think that the separation of power is more sufficient for every state, or just it's kind of methodological or any theory just for the study? But being I being in Pakistan, I'm saying that the separation of power is a very failure part of the constitutional system.
Hmm. Any other observation?
That's all, sir. That's all.
Yeah, thank you. Thank you, brother. When we take into account, and since you have put a question in the context of Pakistan, I should begin my submissions from, on Pakistan in the context of, South Asia. Throughout the history of Pakistan, Pakistan has been an executive dominated state. Political executive dominated state for a very few what you call, intermittent periods of its, existential history. Most of the time, Pakistan, in its history of 75 years of existence, it has been dominated by an executive, and I should, qualify it with an adjective called military executive. You can correct me, my dear friend. And this trend is, linked to the Muslim era and to British rule in the United India when there was no Pakistan and Bangladesh. Muslim Sultan, or you may call them the Muslim monarch, was the chief executive, the sole legislator, and the chief judge in his, dominion, domination, and very reluctantly and dominatingly, they have, ruled. The power of executive, when there is a question of the, separation of power, then the power of the executive, the legislature, and the judiciary were concentrated in a one single individual, and he ruled by decrees. It was the monarchical idea of governance. Power of the, or rather, I should say, let me put it like this: no written constitution is known to have existed during the Muslim rule in the period beginning from the 12th century till the 18th century, when the British, what we call, became supreme in the Indian subcontinent. For governing the subcontinent, my dear friends, the British Parliament passed certain specific legislations. All of you are well acquainted when we were, talking of federalism and other important, observations on constitutionalism. I also reminded these, British legislations like Government of India Act of, 1858, Government of India Council Act of 1861, Minto-Morley reforms of 1909, Government of India Act of 1919, and the Government of India Act of 1935. And that was the final piece of legislation passed by the British Parliament before enacting another piece of legislation called Indian Independence Act of 1947. My dear friends, in the 1935 Government of India Act, the position of the Governor General, or you may call him Viceroy, was unique. As the representative of the British Crown in India, he enjoyed final political authority and the widest discretionary powers and special responsibilities. Supreme command of the armed forces, navy, and other important branches of the armed forces, including air force, was vested in the Governor General or Viceroy. Governor General had extraordinary powers of legislation. He could, however, seek the advice of the council in all matters except defense, external affairs, and the affairs which involved his special responsibilities, and he could seek ministerial advice. He was not bound to act thereupon. It was a different story. Under the provisions of the Indian Independence Act of 1947, the Government of India Act 1935, with certain adaptations, became the working constitution of Pakistan. All the discretionary powers of the Viceroy or the Governor General, concluded or lapsed from August 15, 1947. Indian Independence Act 1947 created the Constituent Assembly of Pakistan and gave it the charge of the nation's affairs, as well as the crucial task of drafting a new constitution for the state of Pakistan. Further, my dear friends, in the Indian Independence Act of 1947, all governmental activities were to be carried out by the cabinet, which was responsible to the Constituent Assembly. Governor General's powers were presumed to be exercised on the advice of the cabinet. In the governmental language or official parlance, Pakistan emerged as a parliamentary government, but in reality it became a virtual administrative state with vice-regal, traditions. Governor General of Pakistan, or later president, enjoyed wide and substantial powers. He was the executive head of the Federation of Pakistan. He had the right to appoint all the important officials, including the Prime Minister, the federal ministers, the heads of the armed forces, and the governors of the provinces, the judges of the higher judiciary, and so on and so forth. The Council of Ministers would hold office during his pleasure. He had the power to promulgate ordinances. Thus, there was a complete centralization of authority, and this is what we have witnessed in the initial stages of Pakistan. In 1935, if you take into account this Government of India Act of 1935, this legislation also permitted the Governor General of Pakistan in certain extraordinary circumstances to dismiss a sitting Prime Minister without the advice or consent of the Council of Ministers. Unfettered powers. These powers were used with impunity by many of the heads of the state of Pakistan in the subsequent or later years. This kind of a vice-regal system which Pakistan inherited at its birth from the Britishers was not abandoned in the subsequent stages or in the succeeding years of its existence. From 1947, my dear friends, up to 1956, when the first constitution was promulgated, Pakistan saw 4 successive governors general, 3 prime ministers.
technical glitch.
Am I audible to you?
Yes, sir. Now,
Yeah.
yes, sir.
Yeah. So I'm sorry for this, brief interruption. In the context of, Pakistan, while appreciating the reception of the separation of powers and its merits and demerits, and the threshold of, respect that was initially attributed by the political class of, Pakistan, I find the cabinet members were mostly selected because they were, friends and cronies. This was just like an era of, absolutist kind of what you call, monarchies. The first constitution of Pakistan that was, promulgated in 1956 abolished the office of Governor General and transferred the same powers to the office of the president, whose executive powers exceeded those of the elected prime minister. The constitution of 1956 provided for a parliamentary and federal form of government. The president retained supreme power and the center was more powerful than the provinces. In the context of Pakistan, my dear friends, in 1958, when the first, martial law was imposed in Pakistan, the 1956 constitution was suspended, and in 1962, the military government promulgated another, constitution. The constitution of 1962 abolished the office of the prime minister, unfortunately, and granting all executive powers to the president. 1962 constitution institutionalized the intervention of the military in the civilian governance, or rather I should say in politics. 1962 constitution was suspended and another martial law was imposed in 1969. And that too after the Ayub Khan resigned following a mass movement against him. And we are also witnessing the long marches in Pakistan in recent what we call years. And this was followed by the tragic events of the East Pakistan crisis, the Indo-Pakistan War of 1971, and the succession of the country's eastern wing. It was seceded from the West wing, which now ultimately emerged in 1971 as a new independent sovereign state on the geopolitical map of the world. And today it is Bangladesh. The new Pakistan, which emerged after the loss of its eastern wing, my dear friends, adopted a new constitution in 1973, and the 1973 constitution created a parliamentary form of government, which is its current constitution. The prime minister was the chief executive of the country, and the president, as the formal head of the state, was bound to act on the advice of the prime minister. The parliament comprised two houses, National Assembly and the Senate. The president did not have the power to dissolve the National Assembly at its own. The constitution of 1973, I mean the current constitution of Pakistan, also provided for 4 provincial governments and the distribution of legislative power between the federation and the provinces. The constitution was not followed in later and spirit, unfortunately. Even 1973 constitution, the provisions for the provincial autonomy were never really implemented in totality. Therefore, we can say that the 1973 constitution made the prime minister all powerful, and the later, through amendments to the constitution, gained even more power. The parliament, therefore, was a legislature in the form and name, but it basically and fundamentally lacked substance and possessed few of the powers associated with such institutions. The civilian yet autocratic rule ended in 1977 with another martial law. The Army Chief General Ziaul Haq dissolved the National Assembly and suspended the 1973 Constitution. 1973 Constitution, my dear friends, was not dissolved but suspended because it contained Article 6, that is a very, very vital, article, which stated that anyone who abrogated or attempted or conspired to abrogate or subvert this kind of a constitution would be guilty of high treason. Deliberately, this kind of a provision was inserted in the scheme of the constitution. Ziaul Haq, instead of a new constitution, issued the Provisional Constitutional Order, that is popularly known as the PCO, and in the subsequent years, again, it was emulated by General Pervez Musharraf. PCO not only gave the military regime the right to rule, but also the right to amend the constitution at its own will and volition. The Chief Martial Law Administrator introduced the Eighth Amendment to the 1973 Constitution, which shifted executive power from the office of the Prime Minister to that of the office of the President. Under Article 58, subclause, I think 2B, you can correct me. The President had the right to dissolve the National Assembly at his discretion. The President thus enjoyed extraordinary powers equivalent to that of the colonial viceroy. Legislature's power was again reduced to that of an advisory body, and the judiciary became a docile branch of the government. In 1997, my dear friends, the then Prime Minister Nawaz Sharif, through the 13th Constitutional Amendment, had the discretionary power of the President to dissolve the National Assembly and other powers removed. Parliamentary sovereignty was ultimately restored, but for a very ephemeral kind of span of time. When policy differences arose with the Army High Command, the fourth direct military rule began in the country, in Pakistan, in the late 1999. General Pervez Musharraf's military coup, the declaration of emergency, and the issuance of another PCO were all validated by the Supreme Court on the basis of the doctrine of necessity, a highly abused kind of creation called doctrine of state necessity. Musharraf got himself elected as the president for another 5 years through a referendum in the month of April, I think in 2002. At the same year, he introduced the legal framework order LFO, which revived all the clauses of the 8th Amendment, and the executive became more powerful, being again vested with the discretionary power to dissolve the National Assembly, appoint the chairman of particularly of the Joint Chief of Staffs Committee and the services chiefs and the governors of the provinces, and made several judicial appointments to the higher judiciary. And ultimately, it was the 17th Constitutional Amendment that was brokered in 2003, reduced the parliament to the level of a rubber stamp. In the period that it starts from 2002, my dear friends, and goes up to 2007, legislative initiative rested solely with the executive, and it was not only executive, it was known as the President of Pakistan, and National Assembly was able to pass only 51 bills, whereas 134 presidential ordinances were promulgated in the same period. See the abuse of power, amount of abuse. And during a period of crisis from 2006 up to 2007, General Pervez Musharraf, who had retained the post of the Chief of Army Staff, along with President, began to lose his grip on the power. In February 2008, general elections were again held, and the Pakistan People's Party, on a wave of the popular sympathy owing to the assassination of late Mrs. Benazir Bhutto, got the majority of the seats in the National Assembly of Pakistan. On April 8, I think, in 2010, the National Assembly removed the power of the President to dissolve the parliament Parliament in a unilateral, what we call, manner. It also removed the bar on a prime minister, serving more than 2 terms. Courts would no longer be able to endorse the suspicion of the, constitution, or, removal of the constitutional, what we call, provisions, or the suspension of the, the constitution of Pakistan. A judicial commission would appoint judges, and the president would no longer be able to appoint the head of the, election commission, or declare himself, what we call, in a unilateral, what we call, manner. Parliament also passed the 19th Amendment to the Constitution, which was, signed by the president on January 1st, I think, in 2011. This created a new system for appointment in the superior courts, aimed at what we call neutralizing a probable source of conflict between the judiciary and the executive. The amendment also raised the number of senior judges as members of the judicial commission from 2 to 4, and also the recommendations for the appointment of the ad hoc, what we call, judges to the superior courts would be made by the Chief Justice in consultation with the Chief Judicial, what we call, Chief Justice, as well as the National Judicial Commission. So therefore, the main objective of the 18th and 19th Amendments is to avoid clash between the state institutions. It was basically, these two amendments, 18th Amendment and 19th Amendment, was primarily designed to function to maintain a balance between the different, what we call, organs of the state, judiciary, executive, and legislature. However, the concept of separation of power has never really worked in Pakistan. Unfortunately, you can correct me, my dear friends from Pakistan in this class. You can correct me in my submissions. It has been the executive which has been the decision-making authority. And most of the time in the history of Pakistan, this executive was dominated by the military establishment, which is popularly known as, if I am allowed to invoke the journalistic language, then it has always been what we call, given some kind of a new attribution, which is primarily known as the concept of deep state. Therefore, Pakistan has been an executive dominated state presidential as well as the parliamentary setting. The decision-making and the power most of the time, my dear friends, has been concentrated in the hands of one person, whether under military or civilian rule. No matter what the constitution says, separation of powers has never existed in Pakistan in reality, in practice, or in practicality, nor has the checks and balances, what we call system, prevailed in the Pakistan. Pakistan has had long, what we call stretches of military rule. If you count, you would be surprised to know that from 1958 up to 1969, led by General Ayub Khan, from 1969 up to 1971 under General Yahya Khan, and from 1977 up to 1998 headed by General Ziaul Haq, and from 1999 October to August 2010 it was led by General Pervez Musharraf. In the remaining years, my dear friends, the civilian governments have humbled and they feebled through their what we call respective tenures, unable to prove their ability to govern firmly and honestly, despite the fact Article 62 kind of provisions have also been inserted in the Constitution of 1973 in Pakistan. The legislature and the judiciary have been merely rubber stamps or acquiescent uninvolved institutions for most of the Pakistan's history. In Pakistan, after every long era of military rule, there have been short-lived periods of civilian rule, or rather I should say some kind of a honeymoon with the sham democracy, because the civilian leaders have shown marked what we call authoritarian tendencies. Lawrence Whitehead, this reminds me of this scholar, has pointed out, my dear friends, that the liberalization does not automatically lead to democracy, and the politicians in Pakistan have never been what we call liberal in terms of their what we call handling of the constitutionalism kind of fundamental principles, which must also be reflected, or likely to be reflected, or must have been reflected in the governance architecture, because it is still, so far the Pakistan society is concerned, we do not find any kind of a middle ruling class in Pakistan, only the elite class, the landlord class, they are still what we call, despite the fact the Pakistan has completed 75 years of independence, but even then it is also suffering from the feudal hangover. And therefore, my dear friends, civilian rule has always been a distant dream in Pakistan. And opposition of a dictator is the product of the, oppressive regime. It has, succeeded. Such an opposition cannot automatically, my dear friends, become democratic after getting power. Democratization, therefore, can only be achieved through regular, free, and fair, what we call, elections based on accountability of the political, leadership in Pakistan. And in this context of, Pakistan, my dear friends, while sticking to the parliamentary system, there should be a separation of power with checks and balances to ensure that the untammered executive power does not what we call emerge. So this is my what we call submission on this particular aspect of Pakistan. I have been very brief in my submissions so far. Pakistan experience with the idea of separation of power is concerned. So this should be taken into consideration. Any questions regarding Pakistan's understanding of separation of powers and how the constitution of Pakistan has been implemented in reality?
Exactly, sir. You are exactly, sir. You are right from the beginning. These are all the gap laws of the Pakistan constitution. But right now the situations are also same as like you were declared that there is a army is also very much interfered in the government system, and behind the system we can say that the ruler of the constitution is army. So that's also I cannot say anything more about it. You know well that what is happening right now. All are the when any government comes.
Are you, brother, are you fearful of expressing yourself since you are attending this class from Pakistan right now?
You know, sir, being an international student, we can say that still 2 months past, we haven't get the visa. This is what in the 21st century, the contacts with the other countries and what is happening now. If the relationship of India and Pakistan in 21st century is for education, we cannot getting the visa, then how we can speak freely everywhere and so what I can say.
So what are the the bottlenecks? What are the impediments? What are the problems which are
The
delaying your getting visa?
So these problems are facing from the beginning. That our ancestors, when they applied for the visa at that time, that they also take the for 2 months, 3 months, and now in 21st century, the being an international student or international laws also happening. All things are happening, but there is no anything. Reasonable that it may make very effective or gets early visa. There are many problems. Don't know what are the main reasons we are happening here with India.
Hmm.
These are being a domestic law or constitution is also under privileged stage, as you say the democratic state. But in parliament, when anyone comes in favor of civilians, as like the Imran Khan, when he stands for the civilians, within 3 years his government was dissolved by the vote of non-confidence. So this is the rule of army. Nobody can go against. That's also.
How do you locate the rights of minorities in the separation of power principle?
There isn't any focus on this rights of minorities, because rights of minorities are also given in constitution. So there isn't any difference from the local government system or any separation power or any special power regarding the minorities. All are given in constitution. That are all.
Yes, you are right. I understand that the rights of minorities have been contemplated in the scheme of the Constitution of Pakistan of 1973. But my context is different, because when we are talking of separation of powers, so the separation of power in terms of the political executive, the behavior of the political executive in Pakistan towards minorities, and I think the Hindus are the biggest, rather I should say, the minority group in Pakistan, particularly in the province of Sindh. Majority of the Hindus reside. So what is the behavior in terms of services, in terms of you know citizens, what we call entitlements, basic amenities, essential services, and municipal services, particularly hygiene and other important what we call civic bodies are there. What is the representation of Hindus, how their rights, particularly right to religion, right to freedom of speech and expression, and other important what we call rights, a right to participation in the governmental activities, what kind of a rights you guys have been enjoying ever since the establishment of the state of Pakistan.
Yes, right now in the current scenarios that we have all kinds of right, and right now in the jo local government, everyone can stand in the local government individually. We can participate individually on our
Do
state.
you understand?
Uh,
Do you understand Hindi?
yeah.
So you can also share your ideas in Hindi, no problem. If you find any difficulty in airing your views in English.
सर बात ये है कि अभी जो सिचुएशंस हैं कि ये कि लोकल गवर्नमेंट जो लॉज हैं या लोकल गवर्नमेंट सिस्टम, इसमें कोई अलग से ऐसे कोई राइट्स नहीं दिए हैंगे माइनॉरिटीज़ के लिए, लेकिन ये है कि हमें हर तरह के राइट यहाँ पे हम एज ए पॉलिटिकली हम इंडिपेंडेंट पार्टिसिपेट कर सकते हैं, किसी भी एरिया से हम कॉन्टेस्ट कर सकते हैं इलेक्शन, बाकी राइट टू रिलीजन भी है, राइट टू एजुकेशन, एवरीथिंग इज़ फाइन। बट फ्रॉम द लास्ट 2 years जो कुछ हालात जो हैं वो ख़राब हैं कुछ मजहबी प्रॉब्लम्स की वजह से। तो ये सिर्फ बस मजहबी है कि सर कन्वर्जन्स जो हो रही है इसके हवाले से बाकी प्रॉब्लम है थोड़ा बहुत, बाकी मजहबी हवाले से ऑल राइट्स हैं, हम अपनी वर्कशिप के लिए भी जाते हैं, एवरीथिंग इज़ फाइन, एवरीथिंग इज़ फाइन। ऐसा कोई नहीं है कि हमें डिप्राइव किया जा रहा है या नहीं। जो पढ़े लिखे लोग हैं वो अपने हिसाब से अपना पावर इस्तेमाल करते हैं, बाकी अनएजुकेटेड कम्युनिटी अभी तक बहुत है इन माइनॉरिटीज। सो आस्ता आस्ता ये भी खत्म हो जाएगा इंशाल्लाह सर।
So in reality, so you are basically I am taking your statement as a politically correct statement. But you have raised one particular problem in your observation, and that is relating to proselytization, that is religious conversion. So because in recent what we call reportings, there have been certain important incidents of kidnapping. Asia Bibi case is also there. She migrated from Pakistan to Canada. Other important what we call incidents have also been there, and these incidents have reported that the minorities are not allowed to enjoy the full-fledged constitutional protection in Pakistan. So, what is the judicial action as far the the rights of minorities are concerned?
सर देखा जाए तो ये कि एज ए रिलीजन ऑफ इस्लाम इज आल्सो द रिलीजन ऑफ स्टेट। सो इन दिस पर्सपेक्टिव जब ऐसा कोई इशू कोर्ट में आता है तो जब मजहब कन्वर्जन हो जाता है तो उसके बाद कोर्ट भी कुछ नहीं कर सकती। कोर्ट ये कि जिस जो विक्टिम है उसका स्टेटमेंट लेगी, उससे पूछेगी आप कहाँ जाना चाहते हैं, तो जो फिर वो डिक्लेयर करे। कन्वर्जन होने के बाद तो वापस वो हिंदू मज़हब में तो नहीं आ सकता बंदा, तो ज़ाहिर-सी बात है फिर उसके क्या राइट्स बचेंगे सर, वो क्या कर पाएगा? उसको वहीं जीना है, जो हो गया सो हो गया। ऐसी कोई खास नहीं है अमेंडमेंट या ऐसा कोई लॉ नहीं है कि भाई कन्वर्जन के बाद आप वापस अपने मज़हब में जा सकते हो या नहीं, ऐसी कोई चीज़ नहीं है। इस चीज़ की ज़रूरत है कि शायद ऐसा लॉ कोई आए कि भाई या तो ऐसा कोई कानून बनाया जाए कि भाई आप बीइंग ए सेक्युलर आप किसी भी मज़हब से शादी कर सकते हो, ऐसा कुछ नहीं है अभी। कोर्ट भी वहाँ खामोश हो जाती है, जब ये बात मज़हब की आती है तो तब कोर्ट भी खामोश हो जाती है सर। जी सर।
Yes, I understand. Yeah. Thank you, brother.
थैंक यू
The
सर।
situation is very grim. You have rightly, pointed out, conversion should not be there, and particularly forced conversion should never be allowed. जो minorities के rights हैं, उनका इस्तेसाल वहाँ पे होना, exploitation होना, and that too on religious, grounds. So that has become, and that is not limited to Pakistan alone. Rather, religious conversion has become an international issue. So all the reports are there in public domain. So we should consider it as an affront to the right to enjoy and propagate one's own religion. Anyway, thank you very much, brother.
थैंक यू सर।
If you can also express your views on any of the issues which are plaguing, and you are expecting some kind of a deliberation in the class, you can also write me email on various issues, particularly in the area of constitution and its implementation, because the government of Pakistan, whether it is the presidential form of government or the parliamentary model of governance, or the politicians, or the deep state, which is the military establishment, they have not been what we call sincere towards the implementation in a very sacrosanct manner of various what we call provisions of the Constitution of Pakistan. So in the name of what we call of religion, constitution, on many occasions, constitution of Pakistan was sabotaged by the military junta as well as by the politicians. So there is no sincerity so far the implementation of the constitution is concerned. Now I take you, my dear friends, do you have any other observation before I proceed to another South Asian country? Any other observation from anybody? Anybody from India willing to express his or her what we call ideas about the separation of power in the context of Pakistan, or in the context of our one friend, Miss Mehbooba Yusufi, she has joined from Afghanistan right now. So I welcome you, ma'am. So what is your idea of separation of powers in Afghanistan, and how the present what we call dispensation in Afghanistan is basically discharging its obligations with regard to the separation of powers, or it is or is it following some kind of a monarchical traditions of separation of powers, where executive, political, judicial, all kinds of powers have been vested in one individual. So what is your take on separation of powers on these lines? Yes, Ms.
Sorry, sir. I just joined the class. I will say my opinion at the end of class. I don't know what is the subject.
No. I'm simply, it is not a question of your joining. I am simply asking you about the working of the Taliban regime in Afghanistan. Do we find any kind of a separate department for each and every activity? Executive activities are also there, the judicial activities are also there, the legislative activities are also there. So do you find any kind of a promulgation, or any kind of enactment, or any law, any decree, any dictation, or any kind of a prescription as of now? Because already more than a year has been completed by the Taliban regime in power. So that was the reason.
Sir, till the Taliban took the government, they apply a lot of limitation on women. I know that all of country know this. That, for example, they do not allow the girls to go to school, or maybe if the girls go out without hijab, they are, the girls will be beaten by Taliban. Yeah, we have this kind of limitation on women.
Right. Thank you. Now, another country, my dear friends, let us proceed further. Another country in South Asia is India, after Pakistan. So we are also having legislative body which is known as a Parliament in India. In Parliament, Prime Minister, Cabinet, Government Department, Civil Services, that is civil services known as executive. Then we are also having the highest judicial establishment in India, which is known as the Honorable Supreme Court of India. My dear friends, in India, we have been following a parliamentary system of government. And this kind of system of governance offers a clear separation of powers. So far, the constitutional scheme is concerned. Judiciary branch is fairly independent of other two branches, that is legislature and executive. But this I leave to the fine sense of judgment of my Indian friends to what extent the Indian judicial establishment is independent. Executive powers are vested with the President and the Prime Minister of India, who are assisted by the Cabinet Secretary and other secretaries in the dischargement of their routine duties or daily duties. All three branches have checks and balances over each other to maintain the balance of power. So that is the basic what we call idea. And whatever the observations I have made in the context of Pakistan, particularly the legislations which have been enacted by the British Parliament, they have equally benefited the incorporation, evolution, and entire what we call separation of powers journey in the context of India. So same kind of what we call structure we also find in the context of India. But of late, what we have been witnessing, that there has been, in the absence of a coalition governance, when one party, a particular political party, is getting absolute majority in the lower house of the Indian Parliament, then the institutional behavior is a different one. Though they are discharging their functions in the name of what we call or within the rubrics of the Constitution of India, but in reality they are exercising their unfettered powers. And what we have been witnessing at the ground level, it is basically, if you allow me to use this kind of a term, you got every right to disagree with me, then we are suffering from the democratic deficit. If I am allowed, with a lot of what we call with due regards and due apology to the sentiments of my Indian friends, I am using this particular because the idea of separation of power in India suffers from democratic deficit. And whenever there has been, whether it was the Pandit Nehru's government, whether it was the late Mrs. Indira Gandhi's government, or Rajiv Gandhi's government, whenever they got some kind of a absolute majority in the lower house of the Parliament, then many of the branches which have been, given separate powers, separate what we call business, as per the constitution, these institutions have suffered a lot. In the political executive has always dominated the rest of the what we call branches of the state. If the executive or the legislature has got unfettered what we call majority, absolute or brute majority in the lower house of the Parliament, then we have been witnessing the decimation, dilution, and deviation of these what we call branches of the state. The judiciary and the executive. But in case of any kind of a coalition governance, when there has been the true what we call we have witnessed some kind of a true governance in an era of that is started in India from 1989, and that is still what we call continuing, and particularly up to what we call 2014, we have witnessed a coalition governance era. Right now we are also having a coalition governance and that is popularly known as NDA. But one political party in this group of what we call the constituent what we call political parties, one political party has got the absolute majority in the lower house of the parliament, and it does not require the support of other constituents of NDA, that National Democratic Alliance, which is popularly known as. So that has also what we call created some kind of a what we call uneasiness, I should say, among rest of the what we call branches, and it is the absolute majority that is dictating the terms to rest of the what I call branches. You can test it, but this is the what we call reality if you are undertaking this kind of a exercise. So it is very, very important to understand these lines as well. Any observation on your part, Mr. Amit Jain, Mr. Abhinav Pandey?
No, sir.
No, sir, what? You do not agree with me? Yes. And it is not at all necessary to be in agreement with me.
Sir, I do agree with you.
So would you like to supplement? Because this is very, very important, my dear friends. Mr. Abhinav, would you like to say something on this issue? Let me give you a larger picture. And the question that comes to my mind is, because in the context of India, for the understanding of the non-Indian students, in the context of India, my dear friends, there is a complete separation of power in the Constitution of India. We have been following the Montesquieuan orientation of separation of power. We have been following this threefold what we call allocation of businesses. But of late, what we have been witnessing in India, that the different what we call departments, so the separate independent branches have also been emerging. And these emergence I have discussed yesterday as well. We have been witnessing the emergence as an independent what we call existence of this branch. We have been what we call witnessing the emergence of the central bank, or you may call it the federal bank. We have been witnessing another important branch that is also that has been allowed to attain its own what we call independence, and that is the what we call media. I'm not saying who is controlling media. I'm not saying media is serving some of the specific interest of the political establishment. No, but the media has also emerged as an independent what we call branch, as a part of what we call of rest of the what we call branches. Again, we are also witnessing the emergence of the civil society in India. That civil society has established itself as an independent what we call group, and that is advising, that is what we call criticizing, that is offering number of what we call alternative views to strengthen certain important institutions and values of a constitutional character. And among them, it is basically the democracy, rights of minorities, fundamental human freedoms, civil liberties, as well as the the workers' participation and whatever the duties which have been accepted, the duties of the state and the part 4 of the constitution of the country. Everything has been what we call there, and that comes from the civil society. Another important institution, that is what we call police. So police has also emerged as an independent what we call establishment with certain important what we call liabilities, duties, as well as what you call, accountabilities. To what extent it is discharging its, obligations, that is still remains to be further, researched and investigated. But these are some of the important what you call. Another important, branch which that comes to my mind is the institution of, ombudsman. Though in the subsequent weeks, I would be what you call, deliberating the institution of ombudsman in the context of, South Asia alone as a what you call a separate deliberation. We would be deliberating at a later stage. But these are some of the important what you call, features of the separation of powers and some of the important, concerns of the separation of powers in the context of India. But here at this stage, before proceeding further, my dear friends, I have another important what you call, submission to make. And my submission is there any kind of a possibility of the regionalization of separation of powers? A larger question I am placing for your consideration. Will it be possible to have some kind of a European Union kind of, arrangement at the, SAARC level to have some kind of a regionalization of separation of power? Because it was basically the first note, I should say, that the European Union is a supranational, what we call, polity, and is neither a country nor a, federation. But as the European Union, my dear friends, wields a political power and is fully aware of its, what we call, all kinds of, deficits, democratic deficits, or some other, human rights, deficits, it attempts to comply with the principle of separation of powers. So even the European Union, so will it be a possibility to incorporate this kind of a political arrangement in the what you call, in the charter of the SAARC nation states? Because there are, in the context of European Union, if you allow me further to deliberate this particular argument, that there are 7 important institutions of the European Union and intergovernmental what you call matters. Most power are basically concentrated in the Council of European Union. And that, I mean, giving it the characteristics of a normal international organization, I should say. And we are also the part of the intergovernmental organization, or an international organization, which is known as SAARC. Here, my dear friends, all powers at the EU level or the European Union level is in one branch. And in the later, there are 4 main what we call actors. European Commission we are having, that acts as an independent executive, which is appointed by the Council in conjunction with the European Parliament, and the Commission also has a legislative role as the sole initiator of EU what we call legislation. Or rather I should say, an early magazine that reminds me, and it was the Commission proposes and the Council what we call disposes. Although the EU's European Union lawmaking procedure is now much more complicated, this simple what we call maxim is still holds some kind of a truth. So it is basically, will it be possible to invoke in the context of South Asia that the SAARC what we call proposes, and the rest of the governments of the SAARC nations disposes any kind of what we call economic integration, the judicial integration, not in the real sense any kind of a political integration, but as well as both executive and legislative functions. The Commission arguably exercises a third quasi-judicial function under articles. This reminds me of what I have studied in the class of, or while researching international refugee law and international protection at the European level. So far the rights of refugees are concerned, that this reminds me of a very, very important article, my dear friends, and I am contextualizing that particular article in the context of separation of power at regional what we call level, at SAARC level, and that is Article 101 and 102. Because these are the articles which must also be taken into consideration, because European Parliament is one half of the legislative branch and is directly elected. So will it be a possibility to contemplate the idea of separation of power at the SAARC level? And I am simply agitating your mind, my dear friends. I should convince you very cogently and cohesively that you should also, come out with some kind of, writing on this particular aspect, because the European, Council itself acts both as the second half of the legislature branch or the legislative branch, and also holds some, executive, functions, and some of which are, exercised by the related what you call, European Council, particularly in practice, because European Court of Justice acts as the independent judicial branch interpreting, the European Union laws. So will it be a possibility to contemplate a SARC, what we call regional court, to particularly in the area of, human rights, in the area of minority rights, in the area of what we call the trade related, what we call, disputes. So will it be a possibility in the, coming future to contemplate these kinds of, institutional, framework, and at the same time, even the remaining institution in the context of, European Union, European Court of, Auditors is also there as a, and that basically functions on the independent, what we call, basis as a, independent audit authority. It functions like that in that particular, in that very manner. So will it be a possibility to have the Council of European Union or, European Commission kind of, arrangements, or European, Council, or European Court of, Auditors, or the European Court of Justice, or the European, Parliament? So will it be a possibility? So we have to undertake these kinds of what we call, aspects, because the doctrine of separation of powers rests upon the recognition of the universal truth that the concentration of absolute power, my dear friends, in one man or one body inevitably leads to exploitation and tyranny. And this reminds me at this stage very, very, very famous what we call, attributions, famous what we call, words of the Lord Acton's what we call, dictum. That dictum wants me, I'm not able to reproduce in exactitude so far the, Lord Acton's, gist is concerned, but I simply what we call, understand the message. Power tends to corrupt, and absolute power corrupts absolutely. That kind of a, separation is there. Therefore, the democratic state has to distribute powers of the state to different what we call, organs, namely to executive, to legislation, and to judiciary. So these are the simple what we call, understandings. But whatever, discussions we have, undertaken, this deliberation is not going to be conclusive. And rest of the what we call South Asian nation states, what we call, arrangements with regard to the, separation of powers, I will continue to submit on those remaining aspects. So thank you very much for the day. If you have any questions, you can email me, and we are going to, very soon, we are going to meet you, all of us, in person in the classroom. So thank you very much for the day. Enjoy yourself. And so far, the recording of these, online classes, both the recordings, you are going to get one recording, you would be getting today, yesterday's recording, and today's new recording, that would also be emailed to you whenever I get it, or more probably by tomorrow evening. So thank you very much for being with me and giving me this opportunity of interacting with all of you. And thank you very much for attending this online class. I'm immensely grateful to all of you. Thanks a lot. The day is still young. Your day.
Thank you, sir.
Thank you very much. Bye-bye.
Thank you, sir. Have a good day.
Yeah. Thank you, ma'am. Thanks a lot. Bye-bye. Take care.